have taken action, they should be man and woman enough to identify their actions and to stand by those actions and to be held accountable for those actions. Insofar as they seek to mislead and deceive and cover up their actions, then those developments ought not to be accepted by the population, and there are those in Trinidad and Tobago, like myself, and all those who went to the president, who will not accept from office holders that they can do what they want in Trinidad and Tobago. And their interpretation, their self-serving interpretation of our Constitution is not going to be accepted. Any questions?
Dr. Al, how do you respond to claims that the president is being manipulated by the amalgamation of the opposition, Labour?
I will dismiss that. Understand, I've seen that being said. The president has a duty to do. You must remember, we went to the president with a document signed by a significant cross-section of the national population. And even if the president was inclined to grin and bear it, or to turn a blind eye, going to the president with that document, after tens of thousands of persons would have marched in the streets of this country, would have indicated to the president, you need to address this matter. So therefore, the timelines of that indicate that the president is responding to the population's request. And this is not an everyday request. It is not every day or every year or every decade that the population is so incensed with respect to an action of a government to have come out by the thousands to indicate in their person that this matter requires attention. That took place in November. On the 20th of November, we went to the president and we asked him to act based on what the population was experiencing. We waited for him to review, and I presume he advised, and he has now acted. So it is not for us to determine if we will reject out of hand any statement that the president is jumping to our music. We are the population. The president and the office of president and the Constitution is our shield against a rogue government populated by people who have allowed themselves to act to favor persons in a way that the population does not accept. That is the issue.
Dr. Rowell, you mentioned the next step the president could take before he mounted to the judiciary, and the judiciary will hold the office for Prime Minister.
I'm saying if as it has been reported and has been put to us by spokespersons of the government, that the Prime Minister has already got to the matter. We are rejecting that as a response to the Section 81 intervention of the President. And we are saying that if that is the answer the President would have got, we are now saying to the President that we are not without remedy. The next step is to the judiciary for an order of mandamus, where the judiciary will look at the situation, and if it finds, based on what is put to the judiciary, the request will be for an order of mandamus, ordering the Prime Minister to respond. And if it is that the response is whatever it is, this particular matter requires the President sharing with the population the nature of the response.
What I was trying to find out, what steps do you wish to take other than ordering the Prime Minister to fulfill the duty? Is there an action taken on the Prime Minister?
We have three arms at the stage here. The Prime Minister functions in two: legislature and executive. The cabinet is the executive. That is where the offense was committed. If it goes to the judiciary has the power to order. Okay? That's what we expect. All that we are asking for, we are not persecuting anyone here. We are prosecuting a process because we want accountability. the public interest has not been served by this development. And we are prosecuting it to the nth level within the avenues available to us by our Constitution. If the Prime Minister takes the position that I am not answering you when the President asks for a report on the conduct of the government on any matter, then that is an office holder who is failing to do his or her job. And in such situation, whether it is the Prime Minister or any other office holder, the courts are available for an order once the court is satisfied that such an order is warranted. But somebody has to report to the court that the office holder has failed to do his or her duty. You see, and I'm saying this against the background that I have now come to the conclusion that the vast majority of people in this country, busy about going about their business when the day comes, focusing on their own life in their own corner, are not familiar with the provisions of our Constitution. And that's why for so long we have accepted this talk about a ceremonial president and that the Prime Minister is all powerful. Office holders have limits to their authority. And the Prime Minister's office, there's a limit to the Prime Minister's office. And under Section 81, that limit is if the President asks you for a report on your government. Doesn't matter what your self-serving sycophants say. The bottom line is, you have a duty to respond to the President. And it is out of order for any Prime Minister to say to the President, I am not answering you because I have done that already. Especially when you are facing allegations of having done what you have alleged to have done, which is to use your cabinet to proclaim a clause of a law in breach of parliamentary trust to allow people known to you to evade the courts. And we will have none of it in Trinidad and Tobago. As long as we have avenues for recourse, we will use those avenues.
This order by the courts, it's one that the Prime Minister cannot refuse to respond to.
I would not profess to want to speak for the court. What I do know is that the doors of the court are available for any person to approach the court if the circumstances warrant. In this case, I'm just putting the conditional notice that if it is that the Prime Minister is telling the President that based on your request to me, I have already handled that matter and therefore I'm going to say to you, then in that case, we don't accept that that is a proper response under Section 81, where it says in simple English that you shall provide the President with any information he requests on any matter of your government's conduct. And in that case, if you have done that, if that's what you're saying to us, because as of now, that's what we've been told, then we know that we have another quiver, another arrow in our quiver, which is that the office of President must now go to the courts for an order against that office holder who is taking that position. Let them tell us it is not so, and therefore we don't have that issue. And if it is not so, tell us what the response is, because we need to know. We are not prepared to accept this matter concluded in secrecy or abandoned out of frustration.
So is it that the courts then, if this is a constitutional breach, is it then that the courts then ask that the Prime Minister appears before the court to answer those questions?
I am not going to presume to speak for the courts on this matter. I'm simply saying to you what the avenue is. Right? Of course, you will get all kinds of legal luminaries to give you all kinds of interpretations. Right?
Should the Prime Minister not respond? What is in store for the Prime Minister?
Should the Prime Minister not respond to the order? To the order? That is not for me to say. That's for the court to deal with. If the court issues an order that you do something and you choose to ignore it, what happens then? We live it all the time. I'm saying nobody in this country, regardless of your state, nobody in this country is above the law. And with respect to public officers discharging their public duty, if you go to the court and you can make a case successfully that the duty has not been discharged, then it is now for the court to determine how to treat with that. That will then be the court's duty.
Dr. The government has already stated their position on this very categorically. I mean, what confidence do you have that any such action will, invoke any sort of different response or information that they've already put out that they may
The difference
just
between
give you?
us and the government is that the government puts out an interpretation to suit its best interests. We are not prepared to accept without question the government's self-serving interpretation, as we were not prepared to accept the interpretation of the acting president when we first went to President House. Because he said to us, he has examined the situation and he has found nothing out of order. Well, okay, fine. But we find something quite out of order when a cabinet note proclaims a law to appoint masters when in fact the proclamation is to create an amnesty. If the acting president finds nothing out of order with that, we find a whole lot out of order with that. As simple as that.
Dr. You mentioned, you said this is one of the avenues, and you said there are other avenues that you willing to speak on what's next, or how do
We
you
will simply let the Constitution unfold. What I'm saying to you is that we are not prepared to walk away out of frustration as long as we have other avenues to prosecute our case. And there's a case to be prosecuted against the cabinet of Trinidad and Tobago for what it has done. And all its entreaties and all its interpretations, right, result in us being told by today's editorial that the matter remains unresolved. We want the matter resolved. We want to know from the cabinet why this was done. Because until we know why that was done, the allegation of collusion, conspiracy, and criminal conduct remains over the head of the cabinet of Trinidad and Tobago. And it will now be compounded if the president's request is brushed aside by the head of the cabinet, who is to be held responsible for this development. So we have great expectations with respect to being brought into the picture. We are expecting that this matter is to be ventilated in the public domain in such a way that the population can be properly advised as to what is happening. And of course, we are not prepared to accept that the Prime Minister can say to the President, I have dealt with the matter already. The Prime Minister is an interested party. The allegation is made against her, and such a response is wholly unacceptable.
What about the view that in trying to look into the Section 34 matter, the President's own actions will be called into account in the investigation?
That is not a serious point. You see, when the cabinet sends something to the President, a proclamation, the President has to do what cabinet says. President then means cabinet. Proclamation is for the cabinet to determine. The President is advised by the cabinet to do this. But I'm sure the President's office will be able to discuss that and defend that. However, even if that was so, the bottom line is, from the very beginning to the very end, the result has been dissatisfaction. And even if the President himself, who was the last signature in all documentation in this matter, is now of the view that something went wrong, it doesn't mean that because he was the last participant in the process that he can't come to a conclusion that something went wrong here. It is self-serving for someone to say that because he was the last signatory in the matter, as advised by the cabinet, that he cannot come to a conclusion, especially based on the information that has been flowing since. Because if you go and examine all the various positions of the various office holders involved in this matter, and you sift out the lies and the misinterpretations and the misrepresentations and the facts, you will see that this conundrum requires clear understanding. Some persons do not want a clear understanding because it doesn't serve their purpose. Other persons want a clear understanding, and that is why the issue is being put where it is being put.
But the government said
providing the population, that is providing, again, that statement is self-serving. Providing that one was aware of what the cabinet was doing and was up to. It was only after the cabinet had done what it did and the beneficiaries sought to obtain the mercy that the proclamation provided them that we became aware of what the cabinet had done. So let us not forget that. Remember, the Chief Justice didn't know when it was done and what was done. The DPP did not know. You had a situation of the DPP going to court in a particular matter and being blindsided and having to ask for an adjournment of a particular matter because it has now been brought to his attention that another matter in another court arose out of Clause 34. The Director of Public Prosecution, who incidentally is now being publicly excoriated by the previous Minister of Justice for some involvement in this matter. If anything cries out for a proper explanation, it is this. Because every single major arm of the state has been tainted by this matter. The Parliament, the Cabinet, the Attorney General's office, the Prime Minister's office, the Leader of the Opposition's office, the Office of the President, the Chief Justice, and the Director of Public Prosecution. Every single one of those offices has been touched by this matter. And that is why there requires to be a proper investigation here so we can find out exactly who did what and find out who is to be held accountable and ensure that the country's records are proper and that this never happens again. In any serious country, it would be laughable for us to be taking advice from people in the way we're being advised to turn away and walk away and let it just go that way. This is a serious matter. And now it has come to a point where the office of President and the office of Prime Minister being portrayed to the country and to the world that the Prime Minister is saying to the President, I don't have to answer you at that in a matter where allegations are being made against her. Do you know anywhere in England or the United States or in New Zealand, Canada or India where allegations are being made against the Prime Minister and her cabinet for conduct of this nature or any similar nature, and the office holder could say, you don't ask me anything because I have dealt with that already? Give me an example. There is no example anywhere in the world that happens. Because when this situation develops, more than ever, the office holders are required to respond and to respond appropriately. There are very frequent instances abroad where the courts are brought in to clarify and to intervene and to restrain and to force and to order because there are persons who will operate your constitution to suit their own agendas and their own interests. We are not to allow that to happen in Trinidad and Tobago. The constitution is there to protect us from that. And this situation has the potential to spin out of control because we are not prepared to accept it if the office holders are not prepared to subject themselves to the conditions of the Constitution. The PLM is the opposition in this country, and we are not prepared to accept any person, any office holder, putting him or herself outside of the pale of the Constitution. Any person in this country can find a handful of persons to run behind him and say, you're right, don't take them on. Fine. When you hold office in this country, you are accountable to the people of Trinidad and Tobago, and we are not without protection from you. Okay? Thank you very much.